Thank you, NYCLA, for putting together this very important program. I think this is a very, very hot topic that is going to be generating a lot of discussion over the next probably few years. So I'm very glad that we're doing this. And without further ado, I'm going to introduce our first speaker. Our first speaker is Massimo D'Angelo. He is a partner at the law firm of Adam Lightman Bailey, PC. He represents condominium and cooperative boards and sponsors, as well as commercial and residential landlords and tenants in connection with complex real estate litigation matters. And he regularly advises and represents clients in real estate administrative and other proceedings. He has been recognized as a super lawyer and a New York Metro Rising Star. And he has extensive experience in conducting trials and arguing appeals in both state and federal court. And he is very well versed on the issues that we are going to be discussing this evening. And I turn it over to Massimo.
Thank you, Judge Moyne, and to Judge Angoran, as well as my fellow panelists, Robert Chesler and Nicholas Nsoya. And I couldn't agree more with Judge Moyne in that this is an extremely hot topic. I'm glad we're covering it today, and there will be years of litigation on these issues. So just a little bit about myself. In addition to what Judge Moyne just mentioned, I am a real estate attorney here in Manhattan. And at the inception of the pandemic, I began publishing and writing and lecturing extensively on force majeure, impracticability, impossibility, frustration of purpose, and business coverage issues. And I've been doing them all across the country. I was retained by several multinational companies, and I am doing negotiations in connection with commercial leases for contractual non-performance as a result of the COVID-19 pandemic. And I represent both sides, both landlords and tenants. So we'll be going through that extensively through the lecture, and we're going to start at the very beginning with the history of force majeure and acts of God, which are actually two totally separate and distinct terms, as you'll see. And we're going to get into some of the how that case law developed, in particular in New York and going forward, some of the other major catastrophes and disasters. I'm a big history buff, so in your materials, with which Ms. Chase indicated is linked to the NYCLA invitation for this lecture. If you download those, you can go along while I go through the outline, and you'll be able to see some of the cases. I also have executive orders that were issued by Governor Cuomo, specifically with regard to the restrictions on social gatherings. So let's get right into it. If you want to follow along with me while I'm giving the lecture, and you can ask questions as well. But we start with the definition. Of course, everything is rooted in the law from Latin, as is force majeure, although force majeure is a French term, but it relates to vis major, which in Latin was a superior force, okay? And it's defined as an event which, as between the parties and for the purposes of the matter in hand, cannot be definitely foreseen or controlled. Okay, so that's the initial premise that we begin with. And, you know, there are not some non-exhaustive examples of force majeure. You have war, you have strikes, riots, epidemics, criminal conduct, okay, and the list goes on. And then you, conversely, you have what's known as an act of God, an earthquake, a flood, volcanic eruption, hurricane. So you can see the differences between both an act of God and a force majeure event. So a force majeure event may cover an act of God, but an act of God is not necessarily a force majeure event. So you have to be clear when you are reviewing these contracts that these two terms of art are and can be separate and distinct. So I think the best practice tip when doing these is to initially look at the contract at hand. You first have to see what the language is that's being employed by the contract that the parties are governed by. Okay, and that's true really with respect to any contractual interpretation or issue that arises. And if we go back in history, we look at the common law, and that's force majeure first comes from. It's the Taylor v. Caldwell case, and I cite to the facts of the case in the outline. If you look starting at page 2, okay, if we scroll all the way back to 1861 in South London, we have these beautiful Surrey gardens. It's a tremendously beautiful music hall that seats thousands of people. And right across the street, you can walk over to these beautiful gardens. They were called the Surrey Gardens. Okay, they were known and renowned throughout Europe. So there's a troupe that contracts with the owner of the venue. Interestingly enough, and you'll see this as we go along here, the contract does not contain a force majeure clause, the typical one that you see. And lo and behold, before the event is to transpire, there's a fire that completely destroys the venue. And we have the holding from Judge Blackburn here. Great language. The holding states, the principle seems to us to be that in contracts in which the performance depends on the continued existence of a given person or thing, a condition is implied that the impossibility of performance arising from the perishing of the person or thing shall excuse the performance. So this is the birth of force majeure. Okay, this is the principle that we all know and think about when we're dealing with force majeure. Okay, so then we get into the executory contract. That's a term you probably have not heard since law school. Remember, what's an executory contract? It's a contract that has not yet been fully performed or fully executed. So the parties still have some important level of performance or an obligation that needs to be undertaken. Okay, and I list some examples here. The ones that I'm dealing with in practice are the real property leases and the commercial leases specifically. Okay, so you still have to pay rent on a going forward basis, and the landlord has to provide you a space in which to allow you to operate your business, right? That's what makes it executory. And Taylor here come to the US several years later. We fast forward, it's 8 years later, 1871, we have the New York Court of Appeals decision, which specifically extends to New York. Okay, and that's in your materials. I've included it as Exhibit 1. You should take a look at that case. And, you know, Taylor was also adopted by the New York Constitution. As I said, I'm a big history buff, so I've included a lot of historical references within the materials. And if you take a look at New York's original Constitution, dating back to 1777, it also applied the common law holdings to New York. Okay, excusing performance, or the res, or the subject matter of the certain thing that is the essential part of the contract is missing or is destroyed by some event. Okay, and we move along here. I've also included Dexter v. Norton in the materials. Dexter, as I said, was it's Exhibit 1. Factually, it's similar to Taylor in that there is a contract, but there is no specific force majeure provision within that contract. And this is in New York City. We're now in 1865. we're dealing with merchants selling cotton. And if you look at a lot of the early cases in New York, which fundamentally created and helped develop force majeure, a lot of them deal with cotton. So here we have certain bales, they were supposed to be sold. Again, we have a fire destroying the substance of the contract. And the issue is whether the doctrine of impossibility, which traditionally discharged performance in the event of death or the destruction of real property, right, as we saw in Taylor several years earlier in England, should it be extended to real property or personal property? And the holding there was that there is an implied condition in every contract which excuses performance, again, where the subject matter is destroyed without the fault of the party. All right, so then we go into some further expansion of Taylor and Dexter in the Supreme Court. We have a federal extension beyond New York. That's the 1883 case, the tornado case, and aptly named Tornado, right? There's a ship. It is in the dock in New Orleans. It's ready to voyage to Liverpool, and it was contracted again to sell cotton, right? We see cotton again. And what happens? Before it's unmoored to take part in its voyage, the ship is destroyed again by fire, okay? And as we saw both in Dexter and Taylor, there is no specific contractual provision, including force majeure. So in the tornado case, the Supreme Court extends the impossibility doctrine in Taylor, holding that the ship was destroyed and could no longer deliver the cotton. So the parties were excused from performance. So you see the same rationale going over in the tornado case, same holding, extending Taylor and its progeny. And then you get into the court-created exceptions following the tornado case. All right, so I have a few examples here. There are several citations I've included in the notes, right? You have legal impossibility where there's a change in law. There was a big development of the force majeure case law historically where sickness or death excused personal services where those services became impossible. I've included the Spalding v. Rosa case, that's Exhibit 2 in your materials. In that case, there was a troop that was actually traveling from New York, I believe, to St. Louis, and they, the main singer of the troop caught a cold, could not perform. So in that case, again, there was an excuse of performance. They did not have to go, payment did not have to be exchanged. Again, going back to the executory contract, could not be performed because the subject matter in this case being the personal services or the person doing the services being unable to perform, to sing. And then I've also included a converse example, Exhibit 3, that is the World of Boxing, LLC versus King. And that Don King is, you know, the famous Mike Tyson manager with the spiked up hair. And in that case, the court refused to extend the doctrine of impossibility, where the boxing match had to be called off because the boxer failed a drug test, right? This is not a person providing services that got sick, but it's somebody who decided intentionally and knowingly and volitionally to take a drug which thereby impeded the match from taking place. We also have where conditions essential to performance do not exist. I've given you several cases there. And also in the outline, Exhibit 4 is the Kinzer construction case. It's a 1910. It's a relatively early case, about 20 to 30 years. And in that case, you had contractors excavating for locks in a canal, and they end up coming into some slippery, greasy clay, rendering it the contractor unable to continue performance of the digging. And why is Kinzer important? Kinzer is very important because although the contract gets terminated based upon impossibility, there is still a permission to recover in quantum merit damages for any work or services that were provided up until that the contract became impossible to be rendered. Okay, and then this segues us right into the current COVID-19 pandemic. I've included a good outline here, I think, of giving some context to the pandemic, what we know about it so far. There's a lot of unknowns, right, about the pandemic. Seems like the information is almost changing on a daily basis. First, we were told by health experts that we had to stay 3 feet away. Now it's 6 feet. First, you could get it and not get it again. You had immunity. So what we know is that we don't know much about the disease still. And there are scientists vigorously working to get a vaccine or some sort of drug to combat this pernicious disease, which apparently remains on metal surfaces for up to 7 days. They say 4 to 7 days. But what we do know is that a ton of people have died, especially us being in New York City. We're at the epicenter of this pandemic. And thankfully, it looks like our numbers are receding, but in other areas of the country, they are augmenting at tremendous levels. I think over the weekend, we had over 50,000 infections in a day. California, Texas, and Florida in particular have been hit hard with this. I think really the populace in those areas has not taken the same precautions that New York took, and it took us about 4 months to really flatten the curve. And what everybody hopes is that there's not going to be this second wave. But that's what we do know about it. It's historically not, I wouldn't say unprecedented, because we have the flu of 1918 in which 40 million people died. Certainly from a fatality level, the flu of 1918 was much greater on a scale of deaths than is COVID. But COVID is still ravaging us. And Fauci, our head U.S. National Institute of Allergy and Infectious Diseases, is opined that we may have 200 to 240,000 people die. So the economic disaster and the human death toll has been astronomical. And as a result of that, in New York, similar to every other state, we adopted these executive orders shutting down most businesses that were deemed to be non-essential. All non-essential businesses were shut down. So I've included those in the materials as well, and specifically Executive Order 202.10, which limited the non-essential gatherings of individuals of any size for any reason. So that was extremely restrictive. That was only increased, the social gathering restrictions were only increased very recently on May 22nd, 2020 with Executive Order 202.33. So that's in your materials also, and you should take a look at those. And especially when you're dealing with these lease negotiations on contractual non-performance, and in particular, if you're doing them in multiple states like I am, you want to take a look at those states' particular executive orders and what they cover. Some states have recently also enacted personal liability for personal type claims. Okay, and we're going to see some other legislation as we go along here. I have some of the comparisons with the 1918 H1N1 virus. And if you look at some of the photographs from that virus to COVID-19, they're eerily similar. And again, I'm a big historical person. I love history and looking at it in the context of the current matters. And you'll see some of the pictures, but people are wearing masks in 1918 and employing social distancing. Businesses were shutting down. So there are very, very stark similarities between the two. And we discuss both force majeure and business interruption together. There are a lot of similarities. And I think that when you are handling these cases, whether it is for a contractual non-performance issue or on the other side of the coin, with the business interruption claims, you're always dealing with the language of your particular contract, right? And especially in the insurance realm, a lot of insurance policies have particular exclusions for virus or bacteria. If you have that, without legislation, there's a good chance that you're not getting business coverage. Okay, and my colleagues will, get further into that in their piece of the lecture. But the same holds true for force majeure and impossibility. You have to look at the language of the contract. And the cases that you should be citing, I've included in your materials: WWW, Associates, Inc., v. Jank and Terry. That is one of the preeminent cases. Vermont Teddy Bear also. And then 159 Corp. Redbridge, which is Exhibit 8. That was a Court of Appeals decision from last year. But look at the language of that case. I really love it. It's, and I quoted it here. In keeping with New York's status as the preeminent commercial center in the United States, if not the world, our courts have long deemed the enforcement of commercial contracts according to the terms adopted by the parties to be a pillar of the common law. So that's great language there, extremely instructive, and a case that you should be dealing with and citing in your papers if you get to litigation, right? We're in negotiation mode now. If you can't work out an amendable deal, you'll ultimately get to litigation where you'll be needing these contractual interpretation cases. So again, does COVID-19 qualify as an act of God to suspend performance? Each state defines specifically what an act of God is and what it constitutes. Okay. So if, for example, your force majeure provision contains reference to a pandemic, an epidemic, virus, or bacteria, the force majeure is covered. Okay. So here I have a practice tip. When your force majeure provision is triggered, next look to see if performance is merely suspended or, in the alternative, terminated. Right? In some instances, even where force majeure is triggered, it may not abate the rent. So you must see whether your client can rely on other provisions within the contract in order to excuse performance. And if you take a look at the appendix, I've actually included real provisions from contracts that I'm currently negotiating on non-performance due to force majeure and COVID on. So take a look at those and take a look where there are discrepancies or contradictions between the two provisions. So you may have a casualty provision saying that fire, destruction, damage, or other casualty abates the rent. And then at the end of the contract, you have a force majeure provision which says it doesn't matter if all these things happen, the rent still doesn't abate. So you have two contractual provisions that do not jive with each other. So what happens? Which one is controlling? Okay, so, and the billion-dollar question is going to be whether, because it doesn't look like the legislatures are going to step in. There's been legislation in the works, in committee, that have gone nowhere. So it's going to come down to a court determination, and Judge Ngoran will, get into this in his piece. also. But, you know, that's the critical piece. The billion-dollar question is whether or not the virus and the microbial matter that sticks on the high-touch surfaces from COVID-19 constitutes a casualty. That's the billion-dollar question, both on a contractual non-performance avenue as with the business interruption avenue. And under New York law, acts of God are specifically defined as events that occur without any aid or interference of humankind and which cannot be avoided by human prudence and foresight. And that's the Merritt v. Earl case. It's an 1864 case, Exhibit 9 in your materials, if you want to take a look. New York jurisprudence is also well settled in that force majeure provisions are narrowly construed and only excuse non-performance where the force majeure clause specifically includes the event that actually protects a party's performance. And the Kel Kim case, which is Exhibit 10 in your outline, is the major force majeure case in New York that you want to know, okay, inside out. In the Kel Kim case, the plaintiff, Kel Kim Corporation, leased a vacant supermarket. There was an issue about getting insurance in connection with the commercial lease, which ultimately could not be procured, okay? And the holding in Kel Kim was that impossibility excuses a party's performance when the destruction of the subject matter of the contract makes performance objectively impossible. Moreover, the impossibility must be produced by an unanticipated event that could not have been foreseen or guarded against in the contract. Thus, only if the force majeure clause specifically includes the event that actually prevents a party's performance will the party be excused. So this is pretty narrow, Kel Kim. Okay, that's not good for tenants, commercial tenants, especially in New York. If you're trying to take the position that your contract has a specific force majeure provision covering COVID, because Kel Kim says it's narrowly construed and it has to be produced by an unanticipated event, which could not have been foreseen. Could COVID-19 have been foreseen? Probably not. So that's going to be an interesting dilemma the courts are going to have to grapple with. And then if we go on here, we see the colossal economic destruction that this disease has caused. It's going to be hard to imagine that the courts are not going to extend the definition of an act of God to COVID-19 force majeure claims. All right, and then we get into business interruption. I'll go through this pretty quickly because I know that my colleagues, Mr. Chesler and Soya, will be dealing with this aspect specifically. There is authority in New York holding that coverage shall be provided to cover the relevant period of restoration of damaged property, but no cases as of today have extended that restoration period to the eradication of bacteria or viruses. And the case that I'm talking about is the Roundabout Theater case, right? Didn't deal with virus or bacteria, but rather physical damage. All right, and if the legislature does not step in, which it does not appear to be doing in any single state in the union, then we are likely going to have this developed by courts, and that's probably what's going to happen. And then very importantly, I think the legislature did not enact legislation further clarifying business interruption and their application following the September 11th terrorist attacks, Hurricane Katrina, or Superstorm Sandy, okay? But at the same token, the business closures that are resulting from COVID-19 are not only local, right? They're not only concentrated in one specific area where the damage occurred, they're everywhere, right? We have had a state of emergency in every single state in the union, which has never happened before in our history. So COVID-19 is a little different in that respect. So according to the law of impossibility, performance of a contract is excused if the performance is rendered impossible by intervening governmental activities, but only if those activities are unforeseeable. Again, that's Kel Kim. So that's the major case you want to be looking at. Specifically, a party seeking to rescind a contract must show that the intervening act was unforeseeable. Okay, so under this rubric, what are we going to have? Litigants are going to be arguing that the governor's orders restricting non-essential travel and shutting down most businesses qualifies as that unforeseeable event at the time that the contract was executed between the parties. Certainly nobody could have possibly foreseen the pandemic, and hence the contract and performance thereunder has been rendered impossible. So we'll see that if the courts take a liberal view of this approach. We just recently had a case that was filed. There's been no determination on it right here on the Upper East Side of Manhattan, where an art gallery moved to hold that performance of the tenant under the lease can be done away with, because the entire purpose of the contract was to have massive people go into the gallery to view the artwork, 500 people at a time. You can't have that anymore due to COVID. So the contract has been rendered impossible. We're going to see how that plays out. It's going to be very interesting. I recently, as recent as last week, was negotiating a very big negotiation with a famous hotel out in Las Vegas on the Strip. And I took the position that there was a casualty under the lease as a result of COVID. The lawyer said, I've never seen this before. COVID-19 cannot possibly be a casualty. And I got a call a few days ago agreeing to a full abatement of the rent due to COVID, saving the client a substantial amount of money. So I'd like to pass the baton on to my other panelists now to continue the lecture. Thank you very much. And I'll be happy to answer.
First participant in the birth of modern insurance law. He has earned his reputation as the insurance guru for his exceptional insurance coverage knowledge, and he is a leader in such new areas of insurance coverage as cyber insurance, IP, and privacy insurance. And we also have Nick Insua, who's a shareholder in the New Jersey office of Anderson Kill. Nick focuses his practice on insurance recovery, litigation, and counseling. He represents policyholder clients in catastrophic first property damage and business interruption claims. He is co-author of Business Income Insurance Disputes, which is a leading treatise on business interruption and time element insurance issues. And we're very pleased to have both of them with us. Take it away, gentlemen.
Hi, this is Bob. The insurance coverage for coronavirus, if it exists under first-party property policies for business interruption. And those are physical loss or damage policies. They're traditional policies. They're not cyber policies, for example. And when you give notice of a coronavirus business interruption claim to your insurance company, the first thing it will say when it writes back to you and denies coverage is that there's been no physical loss or damage. Well, there is case law across the country that indicates otherwise. The first case I want to discuss is Wakefern Food v. Liberty Mutual from 2009 in New Jersey. Wakefern is a supermarket cooperative and it bought coverage in case of a power failure. This coverage, as is typical in property policies, was triggered by physical damage. In 2003, the Northeast power grid shut down, causing food spoilage and business interruption. The insurance company said no physical damage, therefore no coverage. It argued that the grid acted properly in shutting itself down and was never damaged and never damaged anything else. The appellate division said that technically, maybe Liberty Mutual was right. However, the reasonable expectation of the insured was that it had purchased coverage for this loss. And the court looked to fundamental concepts of insurance law, such as reasonable expectations and ambiguity, to make its decision in the case. The court held that property damage consisted of the loss of function of the system as a whole. The court did not require actual physical alteration of property. And this is a major holding, that physical loss or damage does not mean something that's been hit with a hammer and broken. It can mean loss of function, loss of ability to use. And the next major case that followed Wake Firm is Gregory Packaging from the District Court of New Jersey in 2014. A New Jersey company was starting a plant in Georgia, and inside the facility that was being built, there was an ammonia release. A person was injured, the building was evacuated and shut down, and the government evacuated the area for a 9-mile radius. The insured Gregory argued that the building was inoperable and uninhabitable, and that this constituted direct physical loss of and damage to its property. The insurance company disagreed and said there was no physical loss or damage, that physical loss or damage must involve a physical change or alteration to insured property requiring its repair or replacement. The court ruled for Gregory. It stated, and I quote, "The ammonia discharge inflicted direct physical loss or damage to Gregory Packaging's facility, as that phrase would be understood in the New Jersey law of the New Jersey Supreme Court, because the ammonia physically rendered the facility unusable for a period of time." So you have the concept again that physical loss or damage can be loss of use, and that this contradicts the insurance company's basic argument that there is no physical loss or damage due to coronavirus, because with the coronavirus, with the court order, with the governmental orders, there is a loss of use. It's interesting in Gregory that the court did not rely upon the government order that was put into effect evacuating the area, but instead upon the building being uninhabitable and inoperable. Now, the court in Gregory relied upon a number of other cases. The first case in this area that everybody cites to is Western Fire, the First Presbyterian Church from 1968. A church building was saturated with vapors, and the court held that, gasoline vapors, and the court held that this was a direct physical loss. Court Authority of New York and New Jersey by the Third Circuit in 2002 is a second important case. The court in this case said it was applying New York and New Jersey law. It first stated that the presence of asbestos in the building, when the asbestos is embedded in the walls and has to be removed, is not physical loss or damage. It then went on to opine that the presence of asbestos in the air of a building that made the structure uninhabitable and unusable did constitute physical loss. And then there's the Hardinger case from the Third Circuit applying Pennsylvania law, bacteria contamination of home's water supply, rendering the home uninhabitable was direct physical loss. A couple of cases involving unpleasant odors, toxic gas. So there is a body of case law that holds that loss of use constitutes physical loss or damage under a property policy for purposes of business interruption and loss of use and physical damage. Now, I note that all of these cases that I've mentioned are indoor cases where the release occurred inside of a building. Now, if you have proof of a release of coronavirus inside a building, these cases can give you a strong support, but most companies are finding themselves put out of business or locked down, loss of function, because of the external presence of coronavirus in the environment. And I think that's the jump and the leap that courts can have to make, is whether this concept of loss of use applies when there's no release within the facility, but rather outside in the environment at large. I think one important fact here will be the physical nature of COVID. COVID-19, the coronavirus, is not something like an odor. It is comprised of molecules. It goes from one person to another. As Massimo stated, it stays on surfaces for up to 7 days. It is a physical phenomenon. And I think that one way to avoid summary judgment or a motion to dismiss if you bring a case for coverage in this area is to make sure that your complaint sets forth the physical nature of the virus to show that there is reinforce the sense that there's a physical loss or damage to the facility. There are, of course, no cases involving insurance coverage for COVID-19 yet, and it does raise a number of other insurance coverage issues. And I will pass the baton to my colleague, Nick and Sue, to discuss those. Nick?
Thanks, Bob. Good evening, everyone. So the first issue I'm going to touch on is something Massimo mentioned as well, which is virus exclusions. A number of insurance policies have virus exclusions. Not all policies have them. They can come in many different shapes and sizes, so you need to be careful to review. We have an example here of, some exclusions are for microbes or microorganisms, bacteria, fungi. Some will name virus, some won't. There are certainly arguments that a virus is not a microbe or microorganism because it's not actually alive, unlike a bacteria. There's also questions about causation and whether a business's loss was caused by the virus, or was it caused by government shutdown orders that closed certain businesses and forced customers of the businesses to stay at home. And then we have a bullet point here about regulatory estoppel. Exclusions need to be typically approved by state regulators, and there is some suggestion in the material that was submitted when these virus exclusions first came into effect, which was around 2006 or 2007, that the true scope or nature of the exclusions was not appropriately represented to state insurance regulators when these were approved. I mentioned briefly civil authority covers the orders of government. So just to step back for a second, in most first-party property insurance policies, you can get insurance coverage for damage to your property, as well as insurance coverage for loss of business income, which is triggered by damage to property. So if you have a building warehouse that burns down and you can't make your widgets during the time the building's burned down, you can get business interruption insurance. There's also another type of insurance that's very important in these coronavirus and COVID-19 claims, which is civil authority coverage. And this is where damage to other property, it doesn't have to be the policyholder's own property, causes an order of a civil or military authority to close down certain areas or limit or restrict certain types of businesses. Exactly what's happened in New York, here in New Jersey, and just about every other state had either in full for the state, or at least some counties and municipalities had different orders curtailing business. And this coverage provides insurance for lost profits stemming from that action or order of the government authority that prohibits, prevents, or impairs access to your business. Often there does have to be some property damage, either in a geographic area. Some policies don't have that geographic limitation, but there does have to be some property damage. And this gets back to what Bob was just talking about and Massimo touched on also, which is whether the virus does in fact cause physical damage in the first instance. But This is an important type of coverage that we're seeing in many of these claims. Again, it has to be triggered usually by actual property damage. The coverage is usually limited by a number of days. So the example here is where you get coverage for either 30 days or 60 days after the order. So, many of these orders went into effect in mid-March, so if you had a 30 or 60-day period, that would have run out already. Sometimes there's also a dollar amount sublimit for this coverage. Another type of insurance on first-party property policies where you can get insurance coverage where there isn't actually damage to your own property is contingent BI, contingent business interruption, or contingent BI coverage. In some policies, this is called dependent business interruption coverage. And what this ensures is lost profits stemming from covered property damage on either a key supplier or key distributor or customer. So there may have been coronavirus, COVID-19 at a key customer or supplier's location. And if you have this contingent business interruption coverage, you can have coverage for your loss. CBI can also extend to what's called leader or attraction properties. So, think of an amusement park near a hotel, hotel near an amusement park, the amusement park being the attraction property or leader, literally leads customers to your business. If there is the existence of the virus at that leader property, you might have this coverage. So extended business interruption coverage. This is an interesting coverage, and I think it's going to come up quite a bit as we sort of wend our way through some of these COVID-19 claims. Typically, business interruption insurance stops at the time the business reopens or the time it should have reopened. But often a business does not get back to its pre-loss sales levels right when it reopens. Customers may not be coming. They may not even know that you're reopened. So what extended business interruption coverage is meant to ensure is that time where the business ramps back up to pre-loss sales levels. And I think this will be important for many of these claims because as we saw, some businesses might have been closed only for a short period of time. They may be able to technically reopen now, but they're certainly not going to be back to pre-loss levels. And I think this last point is an important one, which is whether this extended business interruption insurance is going to be limited only to a business interruption loss, which will be triggered only by physical loss or damage to the policyholder's own property, or whether this extended business interruption coverage may also apply to other time element types of coverages, such as civil authority coverage. So in other words, if a civil authority kept you closed for 60 days, does your loss stop at this 60 days, or would you get this extended business interruption coverage? So these are just a few pointers on pursuing business interruption insurance claim. You want to always remain aware and proactive throughout the entire claims process. You want to find as many insurance policies as you have. You can find insurance in many different places, not just your first party property insurance. You want to give notice. It was I was surprised in the beginning of the pandemic how many clients were coming to us even asking whether they should give notice at all. I think the insurance industry did a good job of dissuading people from thinking that there would be any coverage for these losses. So certainly it's always important to give notice. If you haven't given notice already, you're advising a client, you should do so. You want to make sure you can properly quantify your claim. These cases, do deal typically, it's not just a burned building where you can estimate the cost to rebuild the building, but you need to know what amount of money your business made in prior years and be able to project what your loss is going to be. You want to make sure you're writing things to insurance companies. If you have a conversation with an insurer, make sure you memorialize it in writing, even if it's an email. You want to be aware of deadlines in your policies. Many first-party property insurance policies have some important deadlines in them, one being what's called a suit limitation clause. This is actually an internal statute of limitations. In commercial policies, it's usually a 2 or 3 year period. These provisions have been held to be enforceable and are shorter than almost all states' statutes of limitations for breach of contract claims. There's also something in these policies called a proof of loss. Even after you give notice, a proof of loss it's usually just a 2 or 3 page form document where you have to provide some additional information about the time of the loss, the scope of the loss. But some policies require them to be given a certain amount of days after the loss. Others require them to be given a certain amount of days after they're expressly requested by the insurance company. So you would just want to keep that in mind. And if you do get the request, make sure you're complying with any time frame around it. You want to preserve records and documents. You want to cooperate with insurance companies' investigation. Almost all policies have a cooperation clause. We've seen many insurers send somewhat detailed questionnaires to policyholders asking questions about the loss, the presence of the virus at their facility, what measures they may have taken to prevent the spread of the virus, clean their facility. You want to be complying with reasonable requests for information from an insurance company. You don't want to lose coverage on an already complicated claim because you somehow failed to cooperate. There's certainly any number of folks, professionals in this area beyond just lawyers, brokers, insurance consultants who can help on these claims. You want to challenge denials. We're seeing almost all COVID-19 insurance claims being denied outright or, long reservation of rights letters sent, which are tantamount to denials. There have been several dozen lawsuits filed around the country seeking COVID insurance, but, the vast majority of our clients are sort of sitting tight. Some of them are challenging the denials. Some of them are just writing, we acknowledge your denial and reserve all rights, and are kind of waiting to see how things shake out. As Bob mentioned, there's very, very little developed law on these. I mean, there's no law on the virus exclusion. There's very little in the way of actual decisions on the merits on whether COVID-19 constitutes physical loss or damage. So a lot of our clients are waiting to see how things play out. As Massimo mentioned, there's legislation pending in a number of states, including New York. If any of this legislation passes, that could be another sort of domino to fall one way or the other. I will say we are having some clients who want to get ahead of the curve now in some ways. They don't want to wait. They're seeing, some pro-insurance company, if not decisions, results, comments by some judges on different motions, MDL litigations being sought and then dismissed. So some of our clients we're seeing, and we've started as our firm filing some lawsuits for clients on these cases who do want to stay ahead of things. Which goes into this last slide. If necessary, you should commence litigation if the loss is large enough and you have the financial wherewithal to do it, and you're not getting the result you want from the insurance company. Certainly consider litigation. And with that, I think our time is up. And if there aren't any questions now, I'll pass it on to our next speaker. Thank you.
Thank you very much. I just want to remind everybody before I introduce our last speaker that if you do have questions, there is a Q&A box. You should see it at the bottom of your screen. I think if it's okay, I'm going to deal with all questions at the end, but please put those questions in the Q&A box. You can indicate if you want whether the question is for all of the panelists or a particular panelist. Either way is fine, and make use of that box. And now I will introduce our final speaker, the Honorable Arthur N. Gorin. Justice Ngorin was born in Queens and raised in Nassau County. He received a BA in English Literature from Columbia College and a JD from NYU School of Law. Upon graduation, he litigated commercial cases for 4 years and was a law clerk to Supreme Court Justice Martin Schoenfeld for 12 years. In 2002, he was elected to the Civil Court of the City of New York, and in 2015, he was elected to the Supreme Court of the State of New York. He is known as one of the most knowledgeable and productive justices in all of New York County, and what he is most proud of is forming and running the Alumni Association of his high school, the Distinguished Wheatley School, located in Old Westbury, New York. Justice Ngorin, take it away, please.
Well, I think I'm the oldest participant, so I got the longest introduction. I've done the most things. So my role here, I've been told, is to give the view from the bench. Well, I thought of going outside. There's a nice park bench right in front of courthouse, but the Wi-Fi won't extend there. So I'm in my surprisingly large courtroom. I have to laugh. Massimo mentioned that the coronavirus only lasts for, I thought it was more like 3 days. Massimo gave a longer time. Back in May, the administration, looking to encourage us to come back here, said, oh, we're disinfecting your courts, we're disinfecting them every day, a week. And I'm thinking, nobody's been in my court for 2 months. There cannot be any live viruses in my courthouse, in my courtroom. So you really didn't have to disinfect it. And the fact that somebody's coming in here to disinfect it increases the chances that something may linger. I want to stress, I may say this again, I am giving the view from my bench, this bench. I may or may not be an outlier judge in certain ways, or about insurance coverage, or force majeure and business interruption, et cetera. But everything I say is just my personal, but also professional opinion. I want to thank certain people. I'll be brief. Michael Cohen, who nobody has mentioned, I believe he's active in the Iranian American Bar Association. He's a good friend of mine. He's been very nice to me. There's the Bar Association itself. Thank you, Farah. And I mention as an aside, I live in Great Neck. If you're Iranian or Iranian connected, you know there's an awfully large Iranian community in Great Neck, so some of you may be my next door neighbors. Thanks to Massimo for his great outline and presentation. The description of Massimo talked all about his professional compliments. He's also just the friendliest, most sociable guy. And I want to comment about his recitation of the cases. Notice it was all very neutral. It was, these were the facts, this was the law, this was the holding. I am going to be judgmental. I guess that's what I'm allowed to do. I'll tell you whether I thought those cases were rightly or wrongly decided. I don't want to get your hopes up too high, because most of them I thought were correctly decided, but not all. Bob and Nicholas, you taught me an awful lot. And as a bit of an aside, I refer to people in private practice as the real world, because you have so many different, and in some ways more obligations. And I think, Nick, your suggestions, they all rang true. That's what I would want to hear about in terms of notices, back and forth, time limits, et cetera. So take to heart everything he said. Barry, thanks for helping set this all up and being so user-friendly. And Nick Moyne, you failed to mention our strange high school connection. If I have you right, your mother taught at my high school, correct? Nick, you there?
Correct, correct.
Oh, okay. When the pandemic first started to take hold around mid-March, I thought to myself, well, there are going to be at least two kinds of cases, a tsunami of them. One is the I can't pay my rent case, which we've talked about. The other is I can't pay my employees case. And I think there are going to be an awful lot of those too, either the employer suing or the employee suing, hey, I wasn't paid. I hadn't really thought much about business interruption litigation, but it's going to be big. So it's important. Massimo talked about cases, maybe actually everybody did, about the question, well, if there's a virus, does that mean the property's destroyed? Well, I'll give you my opinion, the view from my bench. Yes. I think I think that judges exist on a spectrum of how they interpret contracts and legislation. Well, let's talk about contracts. On the one hand, the words, what do the words say? Let's read the words. The other side of the spectrum, and I am an outlier in this, what did they mean? What was the intent? And I often think to myself, what was the bargain? Who got what and who gave up what? And in these business interruption insurance situation, it's the business is giving up money. The insurer is giving up the right not to say, I'm not going to pay for your business interruption. So I would construe them broadly, whether I would call a coronavirus property damage or not, I wouldn't even be that literal. I would just say, this is what the insurance was for when the business couldn't carry on as normal. Kelkim narrowly construed these clauses. I'll lump them all together for right now. Yes and no. You'll see how I feel about that in more particular instances later. I think I would say they should be construed the way the parties intended them. I wouldn't say narrow, I wouldn't say broad. The current pandemic has been compared in some ways to 9/11, Katrina, Superstorm Sandy. Well, let's look at the numbers. In 9/11, I think approximately 4,000 people died. And there were there's other destruction, but 4,000 people. Last I remember, within a day or two, there have been 124,000 deaths. Is that a difference in degree, kind, numbers? To me, it's a huge difference. So I wouldn't lump those cases together. I wouldn't look at 9/11 and say, well, business interruption case is lost, because this is the whole country being interrupted. And I'll jump ahead of myself. Massimo was great on history, and he and I talk about it a lot. And I think the fact that this is the first time in history that every single state has declared a state of emergency is very significant in terms of whether this could have been foreseen, or however you want to phrase that question. It was also interesting the way Massimo was talking about cotton. Why were there cotton cases? Well, because cotton burns easily, I guess. What would be the current analog? Computers that are hacked, that are disabled by viruses? I imagine there must be those cases. The Wake Firm case and the Gregory case, food perished, the grid went down, ammonia released. I think those are rightly decided. That's the view from my bench. Any kind of contamination that prevents a business from operating, whether you want to call it property damage or not, to me, that's what the parties contemplated. I have to tell you another aside. A smart lawyer once said to me many years ago, he said, here's what insurance is. You pay the premium, you pay the premium, you pay the premium, then you make a claim and the insurance company disclaims. Now, I don't have anything against insurance companies. You know, the scales of justice, they're neutral in my courtroom. But I think, yes, I'm not surprised to hear, as we just did, that there are a lot of denials or reservations of right. And by the way, I have to warn you, as you probably know, this court, Supreme, Civil, New York County, et cetera, is on the random assignment system. So if you have one of these cases, you can't just ask for me. That won't work. It'll be randomly assigned. Now, I want to go over some of Massimo's outline in those cases. I hope you're more or less familiar. The Taylor case, where the concert venue was destroyed, no liability on the owner. That's what I would have done. Dexter, where the cotton bales burned, there was an implied condition that they existed. That's what I would have done. I don't think Massimo mentioned, although I think the outline probably mentioned, or maybe not, was a 3-2 decision. So it was pretty close. The tornado case, the other main cotton case, yeah, if the ship's destroyed, you couldn't get what you bargained for, and you couldn't give what you bargained to give. Jones case, where there's a change in law, yeah, if the law, we all know you can't perform a contract that's against the law, that's illegal. So if the law changes, that's good enough for me. Spalding v. Rosa, where Wachtel, the tenor, couldn't sing, I think that's a close case. It might depend on the facts. He couldn't sing because he had a cold. Well, why did he get the cold? You know, could he have prevented it? I would look at that with a bit of a jaundiced eye. The boxing case, in the world of boxing, it was a fascinating case. I think it was rightly decided that the boxer had rendered himself ineligible for the bite, for the bout, for the bite. I'm thinking of Mike Tyson, I guess. And another reason I think it was rightly decided was because Shira Shinlin decided it, and she's always right. But finally, I looked at the case. What I found funniest, if not most interesting, was Donald King said, well, I couldn't have known or predicted that the boxer would have taken a banned substance because he would have known he was caught. And Shinlin said, you couldn't have predicted that he would do again what he had done before? So I think that one was rightly decided. The Kinzer case, which was the canal construction, performance excused, nobody knew that there'd be clay in the soil, I think rightly decided. And I'll tell you what my goal is as a judge. This is the bottom line. Don't quote me on this, but you know, you can keep it in your heads. My goal as a judge is to make the world a better place. That's my mantra, that's my holy grail. That's what I look for. And that's not always easy to tell. And I believe in contracts are sacrosanct, and again, I believe in precedent. But when I put it all together and I'm trying to figure out, well, what am I really going to do here? I want to make the world a better place. And I'll tell you another little secret from Chambers, we'll call these. A lot of times I feel somewhat ambivalent about a case. I may want to go one way. Precedent may suggest another way. Let's say it's precedent that I can ignore. It's another judge of this court has gone a certain way. Well, I want to understand why, but eventually, if I can get away with it, here's how I decide a case. I do what I want, and I say, what's the worst that could happen? I don't want to be reversed, so that's one of the things that I take into consideration. But in the end, I look for the creative argument. I look for an extension of the law if it's not ridiculous. I think that the pandemic itself obviously causes business losses, government closures. I think those would fall under business interruption. And again, back to the words govern. What I found fascinating in the WWW Associates case, decided by Judge Kaye, early on in the case, I think it was part of the opinion, not one of the headnotes, she said, the words generally govern. What does that mean? And then later on in the case, she said, as a rule, the words govern. Well, what does that mean? And is that the same thing as generally? Judge Kaye helped to hire me in my first real job, Owen Conley Chase O'Donnell Lawyer. I have a quick story because I think it sheds some light on the practice of law. She and I were supposed to write an opinion letter. I did a draft, I gave it to her, she marked it up, we got together to hammer things out. On page 2 of the opinion letter, we said something, doesn't matter what. Said something to the client. On page 5, she had added the same point. I thought, well, I got her. I'm just a lowly associate. She's a mid-level partner. I got her. And I said, Judith, we already said that on page 2. And she says to me very calmly, very sweetly, Arthur, I know. I want to stress that point. So I felt like, 2 inches tall and left with my tail between my legs. But sometimes it pays to repeat a point. Although I often tell attorneys who say, well, like I said, you don't have to say it again. I don't remember what I had for breakfast yesterday, but I remember what you said 10 minutes ago. Another smart lawyer once said to me, if you want to say something is prohibited by a contract or not included, don't just say no. Say no, absolutely no, positively no, never. Sometimes a little bit of emphasis is a good thing. The Merritt case where the ship with the horses was destroyed because it hit a mast of another ship that had sunk 2 days earlier because of a hurricane or some sort of storm. I think that was rightly decided too. That was not an act of God. That was an act of the pilot or captain who was running the ship. And that's a really good case for distinguishing between what I would call acts of God and acts of humanity. Practical tip. Okay, we all know that these force majeure clauses, etc., courts will read them in, act of God. Again, I'm lumping them. Here's what I would do if I were drafting a contract. And there are 4 types that I see. One is you don't have such a provision, you hope the court will include it. Well, you're taking your chances. 2, you can include an abstract provision that basically says performance is excused by force majeure, act of God, whatever. Okay. 3, you could have a force majeure provision with specifics, such as, performance is excused by hurricane, flood, firebombing, whatever. But 4th and finally, what I would do is recite general force majeure, act of God language, and then give some examples, and probably as many as you can think of, and then say some sort of, this is illustrative and not limited to these and other acts of God, force majeure, will excuse performance. The contracts that exempt force majeure clause, I would follow the exemption. If it was an arm's length transaction, bargain, sophisticated counsel, et cetera, et cetera, et cetera. Another case to tell you about, which is sort of fascinating. A rich person bought this incredible townhouse in the West Village, Problem was it leaked. Rain fell, water was all over the place. So the purchaser sued. And the buyer says, but the contract says that as is. Contract says you had a chance to investigate. Contract says that to inspect. Contract says you're not relying on anything I said. You're buying this as is. The purchaser said, but you hid things from me. You hid things behind the walls. And I granted summary judgment to the seller because I thought to myself, there's got to be a way that the seller can just say, you will not sue me. You are buying as is, et cetera, et cetera, et cetera. And I think that contract did that. And I would read these exemptions the same way. There's got to be a way that someone says, I don't care about force majeure or act of God. You are liable under the contract if you breach it. So that's what I would do. I think COVID-19, is it an act of God as opposed to an act of humans? I would say yes. That's the view from my bench. You couldn't foresee it. You couldn't stop it. It made a lot of contracts, the intent of the contracts unenforceable. Just a few more points. I've been rattling on for a while now. Does COVID-19 destroy property? I would say a judge open to creative arguments would say yes. I would construe frustration of purpose fairly liberally. And similar to some of the other points about contract interpretation, but a little different and very relevant here because nobody foresaw the pandemic, or you had to be a genius anyway. If a contract fails to cover something, well, what do? Well, here's what I do. I ask myself, what would the parties have said if they had thought about that? You don't always know, you can't always tell, but often you can. I look at a contract and say, look, we know what the bargain was, we know what they meant, or I think I know. What would they have said if they addressed this? Of course they would have said X or Y, or X or non-X. So it's an argument you might find useful. Finally, my big goal in this presentation was to have my head more or less centered on the door behind me. I know I probably moved around a lot, but I hope I achieved that goal. And now I guess we go back to Barry or whoever it is that presents us with questions, and thank you.
Judge Moyne, you want to do the questions?
Yeah, we have a couple questions, and again, please, if you want to ask questions, we encourage it. We have some time, so please put your questions in the question and answer box. The first question is, has any court legally defined either a difference or a similarity between virus and pandemic? Has any court legally defined either a difference or similarity between virus and pandemic? There's a related question to that, but I'm gonna throw that out first.
Massimo?
To my knowledge, no.
I'm not aware of any, and they are mutually exclusive terms that have specific definitions. And if you look at the WWV Jank and Terry case, you have to look at each term. So where two terms have are separately defined, they are defined as such. But I'm not aware of any courts making such a determination.
Nor am I.
Okay, and related to that, the questioner asked, at some point, insurance carriers presented the virus exclusion to insurance regulators for approval. If those presentations to regulators focused on virus and did not include pandemic, could you argue that the losses caused by a pandemic would not be subject to the virus exclusion?
Well, that's easy for me. If the pandemic's caused by the virus, it comes within virus exclusion.
Yeah, I agree with Judge Angoran, and I actually have a situation that is ultimately going to lead to litigation very soon. I have a policy of insurance. I have a commercial retail operator who operates all across the country. We put in a claim for business interruption. I did not have, as part of that policy, a specific endorsement excluding virus or bacteria, and I still got a declination letter back from the carrier indicating that coverage would not be provided on the grounds that COVID-19 does not equate to a direct physical loss. So again, I think it's the billion-dollar question that we've all come back to is, and there's been no court determination on this. We have the Roundabout Theater case in New York. We have some other jurisdictions that have opined and issued determinations on it, but that's the billion-dollar question. Does COVID-19 constitute a direct physical loss? And that question is going to be answered by the likes of Justices Angoran and other judges. So it's going to be interesting to see the development.
I believe what the ethics rules say. I cannot comment on a pending case or an impending case, but I define impending to be a particular case. Here again, perfect example. What did the parties intend? They intended that if the business couldn't be operated, that the insurer would insure. That's how I see it.
So another point, since we have been focusing primarily on US case law and American case law, are there other courts, do you know, are there any other courts, say in the UK or in other European countries or elsewhere, that may be ahead of us on any of these issues?
There is a decision in France that I believe held that the virus was physical loss.
Viva la France.
That's correct.
Okay. Another question is, what about business interruption losses due to civil authority?
Nick?
Seems to me it's covered.
Yeah, so that's, yeah, that was, you know, part of what I was talking about is that, you know, many policies have, you know, in addition to just business interruption insurance, they have the civil authority insurance, which is insurance where an order of a civil or military authority prevents, impairs, or hinders access to your business, and you lose, you know, profits because of that. You can get insurance for that.
Now, interestingly enough, Nick, the situation that I just discussed was the same policy. There was also coverage for civil authority loss, but I still got the declination based on the fact that there was no direct physical loss.
Yeah, I think a lot of insurers are going to take that position that even if you have civil authority coverage, there still has to be physical loss or damage, you know, even if not at your premises somewhere, and the virus does not cause physical loss or damage. Some insurers have said, you know, that the orders are not because of physical loss or damage. They're not orders about property damage. They're orders about keeping people away from each other. You know, so there's going to be, you know, any number of arguments about why this coverage is not going to apply. As I said, you know, all of our clients have gotten, if not denials, reservation of rights that are almost the same thing. Bob, I'm sorry, what were you saying?
No, I was just going to say that civil authority coverage does require physical damage usually as a trigger.
You know, if all an insurance contract said was, we're insuring you for physical damage, This may be inconsistent with what I said before. What is it? Foolish consistency is the hobgoblin of little minds. If all it said was we're insured against physical damage, I would say it does not cover the pandemic. Most of the other things we've been talking about, I think, are covered, but nope, it's not physical damage, I guess.
Okay, if anybody have any other questions, please.
I got one more, Barry, sorry.
Okay,
Can we talk, there has been some discussion about it, but can we talk a little bit specifically in the retail context? Because it seems like a lot of the recent cases have to do with retail stores that are kind of getting a double whammy with the executive orders and also then the economic crash or depression or whatever you want to call it, further impacting their bottom line. What are kind of the issues that, or maybe the special issues in the context of, say, a retail tenant either dealing with their insurance company or with their landlord, trying to get an abatement or some relief under a force majeure clause? I know that was covered, but is there any other specific?
I think it's a great question, and you know, this is what I'm principally and what I've been dealing with over the past few months, and you know, it's already starting. The fallout, I don't think we're even there yet. It's going to get a lot worse. But what we saw first with J. Crew, you see these Chapter 11 filings. Companies are reorganizing. A lot of people think that the brick and mortar, especially the mom and pop restaurants here in New York City, are a thing of the past, will be dead forever. And you see a lot of companies, especially major large-scale companies like the J. Crews of the world, filing for Chapter 11, doing the reorganization, downscaling away from the brick and mortar establishments and putting more money and focus onto, you know, virtual platforms to sell their products and to showcase their products. And what I'm dealing with in a lot of these negotiations is, what do I do first? I pick up the contract, I review the contract, I'll typically write a demand letter, and I pinpoint, especially if I'm representing a commercial tenant, I'll pinpoint the specific provisions of the contract, generally the casualty, fire, and destruction provisions of that contract, which typically indicate that the rent abates. And I'll also cite to the force majeure provision. Typically in these commercial contracts, there is a force majeure provision, but there's that saving grace language, especially if you're a landlord, saying that the rent does not abate. So then you have, I think I discussed it, you know, briefly during the lecture, but you have this struggle, this battle between two provisions in the contract, and who, you know, will the court construe something more favorably towards the tenant or the landlord? And typically it will be towards the tenant if the landlord was the principal drafter of the contract. But then, you know, you have your arguments for and against that. I mean, you look at the 159 Redbridge Tower case. So I think, but when you have two specific provisions in that same contract, which go, you know, are diametrically opposed to each other, I think that the casualty provision will prevail, which specifically provides for an abatement of the rent. But again, we come back to the ultimate billion-dollar question: was it a direct physical loss? And we're going to need, you know, the esteemed judges like Judge Engoron to make that determination.
Dollars goes. I think what Massimo is raising in this commercial context, the mom and pop store, but up from there, that may be the great continental divide here. Which way are courts going to go? I think it's going to be very fact specific. If there was a civil order closing businesses, well, okay, you know, that's business interruption to me. And I would think that leases should be, what's the word, you know, that I'll make it simple. The tenant shouldn't have to pay rent when they're closed. If with economic data or historical or empirical data, there was just no way to run the business, I don't think they should have to pay rent, because the understanding was You pay rent and you run your business. But if the interruption was minimal, I think we're on the other side of the divide. So I think that's why it's the billion-dollar question, because I think it'll depend on how serious the interruption of the business was, where you got the case where the tenant says, well, I couldn't pay my rent, and you couldn't have expected it, because nobody could have expected this.
Okay, here's a provocative.
Can I just continue on that, Nick? Because I have
sure.
one small point that I want to make. And I see this sometimes when I'm representing the landlord and I get a tenant's lawyer who writes me a demand letter that the condemnation or takings provision of the contract has been triggered. I think that is so far off base. It's clearly inapplicable. So that's another thing that I'm seeing a lot of.
That's laughable. I wouldn't buy it.
So here is a provocative question. I want to make sure I get this right. What are the arguments, if any, that this pandemic is not an act of God? And is there a potential time frame during which it stops being an act of God due to steps taken or not taken by humans to stem the spread, such as social distancing and wearing masks?
Nick, just ask the first half again. By the time you get to the second half, it's hard to remember what I was going to say about the first half.
Sure. What are the arguments, if any, that this pandemic is not an act of God? And is there a potential time frame during which it stops being an act of God due to steps taken or not taken by humans to stem the spread, such as social distancing and wearing masks or lack thereof? I guess is what the questioner is also asking about.
I think there'd clearly be a time frame. Every day I followed the deaths and new cases statistics for New York State, and it's going down. It went down precipitously. It's still slowly going down. At a certain point, hey, why don't you reopen your business? You know, people are on the sidewalks and they're buying things. If I were to argue that the pandemic is not an act of God, one thing I would clearly do is look at what has been defined in the past as acts of God. I would look at a lot of cases, and I think you'll find them mostly floods, hurricanes, what we would call natural disasters. Does anybody know, maybe Massimo?
I agree 100% with Your Honor. I think historically speaking, if you look at the old case law and the development of the law in that area, the pandemics or viruses typically are not construed to be acts of God. So I'm pretty sure that this one won't, if we're going based on precedent here. But I think, Judge, one of the cases that you brought up is instructive on the subject, the one where the mast is sticking out of the water, which was ultimately initially caused by an act of God, but then the ship, hits it because it couldn't see it. So I think that's a similar analogy or analogous to COVID-19 in terms of this particular question.
I have, I think, two more, unless people add some. If asbestos rendering a building unusable is considered a direct physical loss, why wouldn't COVID also be considered such?
Well, one obvious difference is one affects the building, the other is solely in people. Although I guess you could argue that people could be spreading it, but I see some distinction between what's in the building when even nobody's there, the ammonia, the asbestos, and something that people have to bring in themselves. But that's just my off the cuff. Anybody else?
I'm
I
with
think the outside versus inside is a distinction that policyholders will have to deal with.
Yeah.
Okay. In Stamford, Brooks Brothers closed their store in the town center mall. Brooks Brothers has not closed most of their stores, only certain ones. Is the landlord in a position to state that Brooks Brothers could have honored their lease and cannot pick and choose which leases to terminate when there are scores of others they are honoring? This question applies to any chain that closes only certain stores during the pandemic. This sounds like it might be an active case, who knows? But
Could be.
in any event, who would like to take that one on?
Interestingly enough, I walked by the Brooks Brothers that's here on the Upper East Side last night with my wife, and it looks like this one here on the Upper East Side is also closing. But I certainly think that that is a position that the landlord could take and should take. I mean, every contract stands on its own legs. So if you have a contract generally what these commercial tenants do is they have a separate LLC or single purpose entity that's set up for each location. So, as a tenant, if I'm a landlord, I'm saying you can't pick and choose which store to close. We have a contract with respect to this particular location. You have to honor your obligations. If I'm a tenant on the converse, I'm taking the position that the rent abates under the particular provisions of the contract.
I can't comment. My lips are sealed, but I wish I could.
Okay. Well, I don't see any other questions or comments. So at this point, I'm going to thank our panelists. This was an incredible presentation that was chock full of knowledge and expertise and guidance. And I think we're going to have to do a follow-up CLE very shortly so that we can digest more of this. And I'm sure there's going to be new developments in this area over the next coming weeks, months, and undoubtedly years. So I want to thank the panelists. I want to thank NYCLA. I want to thank Arani and Barr. I want to thank Michael and everybody, Daria, Barry, Chase, everybody who helped set this up. And I believe I'm turning it over now to Barry for final comment.
Great. Thank you, Judge Moyne. Thank you for putting the program together. Thank all of our speakers, all of our attendees, and I hope everybody has a good evening.